You're welcome.
Good morning. Welcome to the Sports Betting Study Committee. I'm calling the meeting to order. It's October 4th. Thank you all for being here. Our first guest speaker is Tucker Anderson, Alleged Counsel, who will give us a rundown of the primary decision that the committee should be addressing today, which is what kind of regulated market do we want? A licensed market or a control market?
Good morning, Tucker Anderson, Office of Legislative Counsel. I sent some slides to Mike Ferrant this morning that are posted, and Mike, if you could help me move through those so that the folks in the room can see it on the screen and the folks on YouTube can also see it on their screens. I'll move quickly through a review of some of the information that you've already heard. I'll touch upon some minor details from other states to give you examples of how each model is being implemented in some of our neighboring and regional states, and then answer any questions that you have about the two models. I'm hoping that my testimony will be general, but if you have specific questions, I would be more than happy to dig into them.
Just say next slide. I will advance slides.
All right. Well, let's start on page 2, Mike, state control. Perfect. All right. So we'll start with talking about a state control model. The key features of this model: the state plays an active role in offering and managing the system. The sports wagering operators are selected either through a competitive bidding process, or if you're using the lottery model where the state is actually offering its own sports wagering games through the lottery system, then the state is actually creating and offering those games, pushing them through contracted agents, similar to the way that lottery tickets are offered at local agency locations. The state is managing the relationship with the sports wagering operators through contract and franchise. It's also using compliance monitoring and procedures for the enforcement of contract terms, right? The privilege is being extended to the agent through a contract. The contract is the way that the state ultimately can revoke that privilege and interrupt the relationship if it needs to. The state's agents will also use interchangeably operators here, just so that you know it's the same entity when we're talking about licenses and control. Have exclusive rights to offer sports wagering, right? So in the state control system, there's an absolute barrier to entry to the market. And the absolute barrier is that you have to have that agreement with the state. You have to be an agent in order to actually offer it. In addition to applicable statutes and rules, the operator must comply with the terms of the contract with the state. And if you go to the New Hampshire section of the study, and I have it on my computer, and maybe I can share it at some point later in the presentation, New Hampshire has made available to the public the entire contract with DraftKings, and you can see that in the 250 some odd pages of that agreement, they do go into some of the more minute technical and granular detail about, for example, security requirements, financial requirements. All of that is embedded within the agreement between the state and the franchisee, the operator here. The exclusive rights contract typically establishes a revenue share for the state. So in the contract between the state and this party, it is put in there, the state gets X% of whatever the gross gaming revenue is. And of course, the contract will also, depending on the leeway in the statute and rules, define what the gaming revenue is, which when you hear from some of the revenue folks, you'll find is actually an important step in the process. Next slide. Thank you, Mike. The first example, we've talked about it quite a few times in the first two meetings, is New Hampshire. New Hampshire operates a pure state control model. They have an exclusive rights holder. They have one contract. They conducted a competitive bidding process to find that exclusive rights holder. And although they only have one operator that they've contracted with, the statutes did permit the competitive bidding process, allowed the administrative agency to select multiple agents. It just so happened that the revenue share that was offered by that one operator was more than 3 times the next highest potential revenue share. So they decided to go with one rather than having 2 with a lower revenue share percentage. New Hampshire legalized sports wagering in 2019. The statutes authorized the Lottery Commission to operate a sports wagering platform through lottery agents. So again, they're going to use their leverage their lottery system here. New Hampshire statutes direct the Lottery Commission to conduct a 2-phase competitive bidding process. There's a lot of text up on the screen, but the basics are the first step. The Lottery Commission was directed to evaluate, among other things, the financial capability, experience, and background of each of the potential operators. And then in the second phase, after they had gone through all of those, this is your background and your capability evaluations, they collected the pool of qualified applicants that they wanted to consider, and they evaluated just the revenue potential of those applicants in order to select who would be the agents that would get a contract. And it was that second step in the process that led to the sole operator in New Hampshire. And the top sheet of the report, and you can see there's a link in the slides that'll bring you to the actual contract. The top sheet of that contract explains how they went through the competitive bidding process and selected DraftKings. So it was December of 2019 that the commission finished the bidding process and selected an exclusive rights holder to operate. Next slide, Mike. New York, another regional example that I wanted to bring up. It is an interesting state in that it's a hybrid state control model. They do have a licensing structure where operators are licensed. However, all of those operators have to be connected or partnered with a platform provider that is selected through a competitive bidding process that the state agency controls. So New York legalized its sports wagering market in 2021 and directed the New York Gaming Commission to select platform providers through a competitive bidding process and then to issue operator licenses to skins. Those are individually branded websites that have partnered with a platform provider. So there's kind of 2 levels of the licensure here, as I briefly described. During the bidding process, the commission considers the criteria concerning the potential revenue that the platform will generate and financial security of the prospective platform, the background and integrity of the platform provider, and the platform's player acquisition and advertising model. So in that review under New York's criteria, they put a lot on how are you actually going to affect market liquidity, which is one of the factors in the report that can help develop some of those institutional goals, if that's what you're looking to do. How do we make sure that the market is sustainable and strong moving forward? It's one of the criteria New York really focused on. The competitive bidding process required the potential platform providers to propose a tax rate. So in lieu of a fixed revenue sharing agreement, the competitive bidding process said, hey, platform providers, you propose to us how much you're going to pay in taxes on your gross gaming revenue. New York selected 2. They were required to select 2 platforms. And the way that that tax element worked is that they selected, based on a point scale, typically the highest tax rate share, right, from their proposed bidders. But the statute required that both of the operators that were selected pay the same tax rate. So essentially it would come down for both of them to whatever the second highest proposed tax rate was as they were considering their bidders. And the statute also set a minimum tax rate that could be accepted as part of the bidding process, and that was 12%. After the review, the commission is required to award a license to each of the 2 highest scoring platforms, which New York has done. The licenses awarded to the platform providers must apply the same tax rate. Sorry, we covered that. And the commission was required to ensure, as part of this process, that no fewer than 4 skins, those operating licenses, would be in the market. So you had 2 platform providers and no fewer than 4 operators in New York in this interesting hybrid system. Next slide. So to briefly run you through what you've already seen. Controlled market, if we were to break it down into the 2 biggest forms, you got the lottery model. That's where the state is going to be offering its own games through a lottery system. Delaware is the example that I gave you of a kind of pure lottery system, right? They're operating it not just mobile, but through kiosks at casinos, racetracks, and authorized lottery dealers. They have a long history of offering sports wagering as a lottery game. They've been offering what's known as their scoreboard, and maybe it was known as the Pick Six back in the day, starting in like the 1970s. And they offered those over-under style games all the way through the national prohibition of sports wagering. Here you are now.
Stack for me when you come back.
So what would happen if Vermont decided to go down that road? Well, the next initial steps you'd have to make, and again, there's a whole series of downstream decisions that have to be made after this, but start by amending the existing lottery statutes, figure out how sports wagering would fit in as a lottery game and how it would operate through the existing lottery agents. And part of that is going to be determining whether the state is going to create its own platform. That's what DC did. Or whether it's going to use a platform provider. Oregon is another state that operates a lottery system. And they are moving away from offering their own sports wagering app and amended the administrative rules to allow DraftKings to be the platform provider for the state's lottery-based sports wagering system. The other option is go through the exclusive contracts or franchise agreements, and that's going to be the competitive bidding route. The state will determine ahead of time how it wants its administrative agency or agencies to conduct the competitive bidding process, outline how applicants should be scored, and potentially determine how many, either a minimum or maximum number of agents will be allowed to operate sports betting in the state. And again, there's different decisions that could be made if this is going to be strictly mobile or if it's going to be mobile and retail or strictly retail.
Thanks.
Next slide. Move on to the licensed market. Next slide, Mike. Thank you so much. The key features of the licensed market. The state establishes a licensing structure. You've all probably seen at least one of these in your current administrative positions, right? The agency is going to issue licenses based on qualifications set by statute and administrative rule. The privilege is attached to a license to operate. The state manages the relationship with operators through rulemaking, right? The primary instrument before was the contract. This is now through rulemaking. A regulatory compliance structure is going to be built into those rules, and procedures for the suspension or revocation of a license. The state may limit the number of operators or establish an open market system, and I'll give you a regional example of each of these in just a moment. The state then enacts a tax on sports wagering revenue, and that would be set in statute. Next slide. Let's talk about New Jersey. New Jersey was first past the poll, as I've discussed before. They were very fast in getting their market up, and that was in 2018. They started the process the day that PASPA was overturned, and 2 days later, they had their administrative rules ready to roll. So, the Division of Gaming Enforcement in New Jersey may issue sports wagering operator permits to racetracks or casinos. They have a primary license system in New Jersey. I've briefly discussed this before, but the reason there's a bias towards these primary license tiered licensure systems is again because there are in-state physical interests in a lot of these states, racetracks and casinos. Some states, Nevada, kind of the flagship for a lot of these sports wagering, particularly regulatory structures. requires in-person registration before you can use internet and mobile gaming because they want feet on the ground in the casino locations. So next, permit holder, that racetrack or casino can then contract with a licensed casino industry service enterprise is the license that you have to have, but those are your operators, right? To operate online mobile sports wagering subject to the approval of the contract terms by the Division of Gaming Enforcement. So this is the structure you're going to see in most of the states, right? Tiered licensing system. You have the primary license holder typically has some sort of in-state interest, right? And that license holder actually has the regulatory and compliance relationship with the administrative agency. The operator, so think of any of the operators that have been discussed over the last few weeks, then acquire a license typically, but have to partner with that primary licensee that has an existing relationship with the state. And then you have all the subsidiary licenses that come down out of that, depending on if you want to go with retail or if you want to start licensing employees that are going to be dealing with this. Not necessarily a concern unless you have those racetracks or casinos where you have boots on the ground employees that are going to be interacting with the sports wagering system. New Jersey limits the number of skins. There's skin limit state. There's a chart in the report that breaks down the minority of states that have limitations on individually branded websites. But they limit the number of skins that may be operated by an individual licensee. So those racetracks and casinos are limited in the number of operators they're allowed to have these agreements with. Each licensee is limited to not more than 3 individually branded websites that can be operated. New Jersey has a 13% tax on mobile sports wagering revenue, and they have this interesting additional tax of 1.25% that goes either to the casino kind of redevelopment fund. I can't remember what the name is, Casino Reinvestment Development Authority, or it goes to the municipality where a racetrack is located, depending on who the licensee is. The recap, this is an example of a licensed market. Again, this is the classic gaming control board model. You have a primary license with a relationship to the state, and then you have the subsidiary license actually being the operator who comes in and, once you take the geofence down, allows access to their product in your state. Next slide. Massachusetts, and I brought this up because I wanted to get the borders and discuss what's happening in the borders. Massachusetts is brand new. So August 10th was the date that their sports wagering statutes were signed into law by Governor Baker. So very recently legalized. They granted authority to the Massachusetts Gaming Commission to oversee the licensing structure in the Commonwealth and to start issuing temporary licenses immediately. And I believe that what they have done is $1 million and an application will get you access to a temporary license with a follow-up review for a permanent license after that. There's some important restrictions about operators in the system that we should cover. So the Massachusetts Gaming Commission may issue a mobile sports wagering operator license to any qualified entity. So this is more open than what you're seeing in a lot of the gaming control board states that had these systems before 2022 when Massachusetts enters the scene. So any qualified entity, you meet the standards, you can operate mobile sports wagering. However, there are enumerated limitations. The commission shall issue no more than 7 mobile sports wagering licenses that are not connected to a category 1, which is a qualified gaming establishment, i.e. casino, or category 2 racetrack license, right? So there are no enumerated limits out there. There's a de facto limit if you're connected to one of those existing licensees. If you're not connected to a casino or racetrack, then the limit is 7 operating in the state at any given time. Category 1 licensees, there's a limit. They're only permitted to partner with 2 branded websites. And the category 2, your racetracks can only partner with 1 branded website. Massachusetts has determined they're going to impose an excise tax of 20% on adjusted gross sports wagering revenue. Next slide. So this is the last slide. You've seen this before. Quickly work through some of the decisions to be made around a licensed market. First consideration, because Vermont is kind of a blank slate, blank canvas state, right? We have a lottery, but otherwise wagering is a prohibited criminal activity in this state right now. One of the first considerations is if you go down this road is who are the primary licensees going to be? Are you just going to issue licenses to the actual operators? Absolutely a choice. If that's the route you go, you might want to check out states like Tennessee and Virginia, where there wasn't a massive or none at all casino presence. Those might be good states to look at. Are you going to go the Arizona route and connect it to some sort of in-state sports interest? Right? They connected it to their NFL teams, their racetracks, the PGA Tour, in an effort to kind of target that vertical alignment between the actual product, the sports game, and what is being sold here, the value added contract where you're wagering on the game. Or are you going to go potentially the New York route and have some sort of hybrid system here and say, we're going to have platform providers. We're going to limit those, but then those platform providers that we are now establishing this strong connection with through this bidding process, they're the ones that are going to be the primary licensees that all of the operators will go to be able to offer sports wagering in the state. So targeting some of that hybrid between control and licensure there. Depending on whether you're going to go down the retail route or not, you might have to get into some of the subsidiary licenses there. Like I said, during the first meeting, I did not get into the trees that come off of those, but you do have a lot of other potential actors in this space that you would want to license and regulate. And again, that's up to the interest of you all as you make these decisions. Caps. When JFO talks about some of the numbers, they will likely talk about the impact that the number of licensees can have on the revenue in the market. So there's a lot of evidence out there that having a lot of licensees and a lot of various products and competition in the market can drive market liquidity. Some of the revenue numbers may not match up with that, but it's something to consider. And in fact, there's quite a bit of testimony from 2020, and I might actually have to share my screen to talk about some of the work Vermont's done in the past. But in 2020, there was some testimony, including from Kip Levin, about how the number of licensees competing in a market can have an impact on overall revenue. And I can point folks to that testimony and some of the earlier Vermont bills if you would like. Enumerated cap or no enumerated cap, or is it going to be based on, are we going to drive something to an in-state interest or not? Something to consider. Then you move down the line, applications and qualifications. Are there institutional needs or desires that you want to build into the licensure process to make sure you're erecting barriers to entry that won't allow unscrupulous or unwanted actors to enter the space? You see that barriers to entry exist in every licensure system, certainly that I have dealt with. So that's something you want to consider here. Developing a compliance review, suspension, revocation process might not be necessary, for example, in statute, but determining how to get your administrative agency to go through with that is part of the legislative process for sure. And then you have all of those more granular decisions that might have to be made down the line. Background checks, periodic reviews. There's a law review article from the University of Nevada, Las Vegas that I linked to in the report all about how having a very robust and routine review process has kept their industry alive, because they focus primarily on integrity of the system and preventing encroachment from the illegal and illicit market. So they work a lot on those regulatory levers that I quoted a lot in the report. Potentially requiring systematic audits, things like that. Again, more granular, but those are decisions that could be made in a future bill to make sure that they show up later on in the administrative agency's rules. And then each of the next three will apply equally in both of the systems, but you see a lot more of them built into the statutory requirements for licensing structures. Consumer protection, house rules, minimum internal control standards, financial reporting, accounting procedures, and collection of taxes. All things that will have to be considered, and again, often in the statutory structures are built in explicitly so that they can be relied upon by the administrative agency in rulemaking, and then in enforcement later on if they have to suspend or revoke a license. So I do have some of the bills that have come up in the past. I can briefly describe them. I don't know. I probably have to log into the Zoom to be able to.
I think, so we're at 12:08. We all are also having Graham talk about the revenue implications of these models, and then we want to have a discussion. Do we want to pause for a second and see if anyone had any questions for you, Tucker, before we ask Graham to get into the revenue? Does anyone have any questions for Tucker on what he's presented in terms of the state control model versus the license model? Thanks for joining us, Matt. I know your time is condensed today. I appreciate you coming on. I know you're mostly listening, so. Any questions or thoughts for Tucker right now?
It's a pleasure to be here. Glad I could join.
Thank you. Okay, so can we have Graham? Hi, nice to see you, Graham.
Hello, good to see you too, Commissioner Knight.
Would you run us through your presentation that gives us a sense of the revenue implications of these models?
Sure. So for the record, my name is Graham Campbell. I'm a senior fiscal analyst at the Joint Fiscal Office. I did not prepare any sort of formal thing for the committee. So there's nothing really on the committee's website. I was the author of the revenue parts of the report that Tucker referred to earlier. I've since sort of transitioned this portfolio and JFO over to my colleague, Pat Titterton, but he's on his honeymoon. So in future committee hearings, if you are going to bring JFO, you will likely deal with Pat Titterton. That being said, I think I can bring some information to the committee with respect to the revenue side. I'll begin first by saying that my knowledge of the regulatory structures in every state does not even come close to the level that Tucker has. My focus here was primarily on coming up with a revenue estimate for a legal sports gambling market in Vermont. However, as I got into that experience and learned about how other states structured their markets, as you saw in the report, the various revenue estimates were dependent upon the various proposed structures that other states did, and subsequently what Vermont could put into place. My first point that I want to bring forward to this committee before I start talking about revenues is that the amount of revenue that we're talking about here for the state is relatively small. It's not a panacea. I want to sort of drive that home. And this is me wearing my Joint Fiscal Office cap and dealing with the budget. I mean, even at the highest end of what our revenue estimates are, which is around $10.5 million in the second year of implementation, you're talking about less than 1% of either the education fund or the general fund just on the state side. So you're talking a very small amount of money in the grand scheme of things. And I think I mentioned that in the report, that even though you hear very large numbers coming out of places like New Hampshire or Rhode Island, similar states of our size, those revenues do not represent a very large share of money, even less than 1% generally of their general fund or education trust fund. So we're talking not, I mean, obviously I work in the budget a lot, and so every $1 million is a big deal. But, you know, I would caution any sort of recommendations about utilizing this money for sort of very large or ongoing growing revenue expenses. So that's my first spiel about being cautious about this money in terms of the size. I think the experience that I can bring and the information that I can bring to this committee with respect to tax revenue is to say that based upon my conversations with stakeholders is coming up with the revenue estimates and looking at how other states are structured from either a state control or licensure model that Tucker is referring to, is that the model that you all choose is not, the impact on revenue is not necessarily as tied to what the model is. So to give you an example, Rhode Island is a state control model, right? And so is Oregon, but the amount of revenues that those two states generate on a per capita basis are vastly different. And so the model in and of itself is not a strict, determination of what the revenues we think could come from this. I think what is more important for revenues, and Tucker touched upon this, is the quality of the operators that are being solicited by the state if it is a control model, or the quality of the operators that are operating a state under a licensure model, and or the amount, the number of licenses being in a state. And I'll touch on these in kind. So in places like Rhode Island and New Hampshire, they have, I think, a relative, like a straight control model, but they generate relatively high per capita handle being the amount of total betting that is generated in the sports betting market in any given month. What makes their markets, I think, relatively successful is that they're because they don't necessarily have a ton of licenses that they're issuing. I think Rhode Island has 2, New Hampshire I think is just 1. Is that the quality of the operators that they chose basically leads to the fact that the lines and the competitive bid, the lines that gamblers are able to access, and the sort of promotions and quality of the market, the developedness of the market, leads to a lot more betting. And so I think in the case of New Hampshire, when I spoke to a stakeholder about this, was that DraftKings basically has the same lines and offers a ton of promotions to New Hampshire gamblers. And that's what drives very high per capita handle in their state. Not necessarily the fact that they don't have very many operators or licenses in the state. And so the quality of the operator is really, really important when determining, because what you really want is not necessarily lots and lots of operators licenses. A state like Vermont could probably survive, or might end up with a case where you have just 1 or 2 quality operators. But what really matters is that the operators themselves are competitive with Las Vegas lines. The people who typically gamble on sports are a large amount of the betting comes from a small number of people, and those people tend to be very savvy, and they're looking for arbitrage opportunities, and so they're looking for the best places to place their bets. And so the reason why places like Oregon, being an example, in DC, prior to them opening up their market a little bit, the reason that they were, in looking at the sort of revenue numbers, were generating low per capita handle was because they were a state control model, but they were mostly just operating as a state system, and not their lines and the sort of products they were offering were not competitive with other states and or illegal gambling operations. And so that's why they weren't generating as much handle. So you look at it's like going back to, say, Rhode Island or New Hampshire, they are under a sort of state control model, but they have a very reputable and quality operator through which people can place bets. And so that leads to a competitive sports gambling market and lots of betting. If you look at a place like, say, New Jersey or Illinois, Tennessee, all these are sort of license models, and they generate a lot of per capita handle, but it's not necessarily, in one way, it's because they have so many licenses, they have many different operators, but because they have so many operators, any one operator cannot offer, they need to offer high quality lines and promotions. And so that drives the betting in those states. And so I think my takeaway from doing all this revenue estimating last summer was that if Vermont were to go with a control model, if the goal was to maximize revenue, then the goal should be to contract with a very high quality operator or operators in order to drive that revenue. The other sort of factor here, which is much more direct, is in addition to generating a very robust market for gambling, the tax rate is very key, right? So in New Hampshire and Rhode Island, the revenue share is 51%. And so that generates a lot of revenue. But what I would also add to this discussion is to say that in a small market like Vermont, it is our sort of, after talking with stakeholders and talking about revenues, is that sports books, it would be very difficult for Vermont to operate a model very similar to New Jersey's with a high tax rate. So imagine you have many, many licenses with a tax rate of, say, 40–50%. And that's because Vermont's market's not very big. There's just not enough space for many operators to be in the state and to pay a high tax rate. It would not be worth it to them. And so I think that's one potential reason why states like New Hampshire and Rhode Island have gone with a different approach of, fewer operators, but high tax rate. And so that's another factor I think that the committee should think about. But in terms of the overall revenue estimate, the way we did it in the report was we characterized it on a matrix of sort of 4 parameters. So the 2 parameters: either you were a high operator state, a many operator state with, or a sort of high quality operator state, or you were a few operator state. And so when you think of few operator state, you're thinking about states like Oregon, DC, Montana, Mississippi, Arkansas, where you can only really bet in person at the casino. And then whether they had a high tax rate or low tax rate. And so you had sort of 4 different revenue estimates depending upon the model that Vermont chose. Obviously, there are lots of different sort of regulatory wrinkles that would need to be ironed out here that Tucker, I think, has gone over. But generally what we found is that under sort of a many operator / high quality operator scenario with a low tax rate of, say, 10%, you're looking at revenue in the first year about $1.5 million to 1.75 million. And then you're looking in the second year, you're looking at about revenue of $2.25 million. So that's under a low tax rate, many operator scenario. Under a sort of many operators / high quality operator scenario with a 50% tax rate, similar to Rhode Island, New Hampshire, we estimate the revenues would be around $4.8 million in the first year and north of $10 million, $10.6 million in the second year. But under the sort of fewer operators parameter, with a fewer operators, low tax rate, in this case, the tax rate was about 15%, because that's what we've seen in those states, a little bit higher. You're seeing significantly less revenue estimate, about $640,000 in the first year and about 1.4 million in the second year. But if you use a higher tax rate under that scenario, about 50%, you could see revenues of about 2.6 million in the first year, and again, about 2.6, 2.7 in the second year. I think to sort of wrap all this up, again, what you sort of trade off here with respect to revenue is with if you went with the state control model and say decided that the Department of Liquor and Lottery were to be sort of the primary sports book, and the Department of Liquor and Lottery would have to come up with their own sort of, look at the lines, generate lines, their own promotions, things like that, similar to how liquor works now. Then on the one hand, what you see in other states is that they're able to generate very high what's called holds. So basically the sports book wins a lot more. So that's a potential advantage there. But the problem is your market that enters there, that's betting in that market, is a lot smaller because it's just not as competitive. What you see in the many operator states or the high quality operator states is that the holds are uniformly lower. So the sports books aren't making as much money from just the gambling, the being on the right side of the bet. But the sort of market is just much more robust. The base that we're talking about is much larger. And so they're able to sort of tolerate lower profits. And then at the same time, by the time the sort of state steps in is asking for a revenue share, in states like Rhode Island, New Hampshire, they're more willing to contribute larger revenue shares because there's such a robust market under these scenarios. So to sort of sum up my points here is that I would say that the model doesn't necessarily determine how much money. The difference between a state control and a licensure model does not determine. What is most important is the competition in the model and then the tax rate. So if you were able to generate competition in a robust market under either scenario, that would be ideal for the revenues overall. And then it's just a matter of determining what level of tax rate you would want to apply.
Thank you, Graham. Any questions for Graham? Okay.
Thank you.
So should we have a discussion then about the primary question before us is looking at the regulatory market? Do we want a state control? Are we recommending a state control market or are we recommending a licensed market? That is the question before us today in terms of our recommendation to the General Assembly. Matt, I know you're pressed for time. Do you want to join in right now with your thoughts and your preference? If you're hearing us and able.
Yeah, yes, thank you very much. I am able. I just had a official phone out of my pocket. Thank you very much for your patience. Now, everything that I've seen so far, I am leaning towards the state model. I think it's structurally more viable for us to get up and running, monitor, et cetera, et cetera. So just to keep it brief, that's where my head is.
Thank you, Matt. Representative Odie, you still with us? Do you have any thoughts or questions or any preferences to the state control model or the license model?
Yeah, well, I had been leaning toward the licensure, thinking about competition being more robust if we did licensure. But I listened carefully to what Graham Campbell just went over, and I just would say the competition in the model and the robustness is key. And I know that we could, with the state control, we could issue multiple licenses for more competition. But So anyway, I'm okay with, I'll listen to more discussion.
Okay. John, did you have any discussion points or any thoughts, any preference on the state control model or license model?
Yeah, sure. I think my thoughts listening to Graham was just, I don't think with Vermont's population and the fact that we lack like home teams, like a football team or something like that, we're just not going to generate the amount of sports betting that I think other states that have many operators under license competing with each other. I just don't see a situation where we're going to have that much competition through licensing. So I think the way to ensure that we have competitive lines is probably what Graham was suggesting, which is to have one or two really good operators that are going to give us those competitive lines so people actually participate. So that would be my thought, I think, would be to use a state operating model.
Okay, thank you, John. Chris, are you still with us? Do you have thoughts and discussion points? Preference?
Sure. Yep. Still here.
Thank you. Appreciate it.
Listening intently, doing a little bit of multitasking here. Had been leaning toward the licensure model. I do have quite a bit of experience with licensure and structured correctly. I think it's probably less difficult for the state to put together. It seems like the state control model relies on having a lot of expertise and infrastructure and resources in place, like a gaming commission or something like that, which we don't have. So I have been leaning toward the licensure model.
I thought I understood. Thank you. I thought I understood that the licensure market relied on those established gaming commissions, which we don't have.
Oh, do I have that backwards?
Well, based on what you said, if you're thinking that it would be too much effort for us to establish gaming commissions, that's a fundamental structure of the licensing market. Tucker, am I getting that correct?
Yes.
Correct.
Okay, reverse that then. I think I agree with what everyone else has said before me then, that the state control model is the better model.
Because it's not going to be as difficult to set up a gaming commission. Is that what you're trying to say? Okay.
Correct.
And Curtis, what are your thoughts?
Well, I mean, I guess I have just questions around, ultimately, what is the goal? Is it revenue generation? Is it oversight? Is it control of the marketplace? Is it competition? Those are all the questions that are kind of going through my brain. Because in terms of deciding on a model, it seems to me, or making a recommendation to decide on a model, it seems to me the committee needs to grapple with, what's the purpose of what does the state want and what's the recommendation of this body? I'm not prepared to represent, I think the Attorney General is here representing consumer protection interests. We're agnostic more or less on the question of what regulatory approach or model the committee recommends or is ultimately adopted by lawmakers. And but I do think that those are the pertinent questions. It's like which model gives which result that the state is logically seeking. And so maybe some of the discussion could revolve around those questions, which might help the committee get to a certain conclusion.
Thank you. I see that Senator Rahm, Hinsdale, and both Tate have emailed the committee. Tate supports the state control model, and Senator Rahm, sorry, just reading this now, prefers a state-controlled system. So it feels like Senator Carol Odie, Representative Odie, did you want to
I'm
come back to the conversation?
No, I'm fine with that. I think I heard more clearly today that since we don't already have operators in the state, that's where licensing works better. And I was heartened by what I heard from Graham. So I think as long as we have competition in that model, that it's robust, we set the right tax rate, we'll be okay.
Okay, So as to the question of which model we are recommending to the General Assembly, the committee is recommending a state control model versus a licensed market. That we have decided today. The next series of questions, which will be now that we've decided that our recommendation is a state control model, as you recall, Tucker was walking us through some of those other decision points, and we still have an hour left. So if you would walk us through some more of this slide here, Tucker, where we look at in a state control model, that market, another key decision point would be, do you have exclusive contracts, the competitive bid process where the state seeks bidders and operators through a bid process? Or do we set it up where it's the state actually has a sports book, like you mentioned, DC did at one point, and Oregon had that and they're moving away. So maybe you just want to walk the committee through those two different models within the state control model?
Absolutely. So again, Tucker Anderson, Legislative Counsel. This is on page 5, slide 5 of the presentation I went over earlier this morning. It's also in the presentation from the first meeting. The two primary structures within the state control model are the lottery system and then the exclusive contracts franchise agreement system. As the chair pointed out, some examples of the lottery-based system would be Delaware, DC, and Oregon. You heard some of the revenue implications of making that very specific choice to have the state lottery be the system for sports wagering, and some of the administrative challenges that might come with that. But again, under that system, the state would be essentially the sole operator, and your lottery or potentially the administrative agency over the lottery would actually be not only managing sports wagering in the state from an administrative perspective, they would be directly offering it through the lottery system. What would be required, at least legislatively, would be an amendment to the existing lottery statutes to authorize sports wagering games, or to authorize the existing lottery system to offer new types of lottery games, which would include sports wagering. And then determining at this point whether the state is going to create that system or whether the lottery is going to leverage some third party to have, for example, as Oregon is doing now, DraftKings or some other operator come in to actually provide the product. But again, the lottery would still be in control of that. If this is the direction you decide to go in, the chair probably has some resources about the existing contract structures that are used within Vermont State Lottery right now, and how some of those kind of third-party relationships play out with respect to the products that the Vermont Lottery offers. But you would be kind of fitting sports wagering into that model. If you go through the report and look at some of those states, one of the things you'll notice is that the lottery states predominantly were states that were able to offer sports wagering during the nationwide prohibition. I covered in my earlier testimony, Delaware was one of those states. The nationwide prohibition, which was in the Professional Amateur Sports Protection Act, prohibited sports wagering unless a state already had a sports wagering system in place, in which case they were allowed to continue to operate that system, but they couldn't amend it or add to it. They couldn't expand their existing gambling market. So during the 25 years that was in place, what you saw was states like Delaware and Montana kind of keeping those lottery systems in place because they were allowed to do something that other states were not. Something to consider when you look at it, because that leads into what's the new model then? Well, the new model was DC. And if you look at the report, DC's system was, and I do not mean this in any negative light, but complicated. The reason it was complicated is they had site-specific retail wagering where stadiums were given licenses to allow wagering, but only on premises at the stadium. And then they had a control model for everything outside of those stadiums, literally the sidewalk outside, I guess is maybe where they would have geo-fenced it. But throughout the entire district, DC controlled through their own individually branded sports wagering platform that they created. And I wish I could remember the name so you could take a look at it, but it did take quite a while for them to launch, which is the risk that I believe is highlighted in the report, and that I'll at least highlight for you now, is that launching a lottery product, particularly if it's going to be something that you create, is a huge risk. And takes a lot of resources to develop and launch. And something that you see in almost all of the states, especially those that have come in, let's say since 2020, 2019, is that market launch can be a really important driver for the health of the sports wagering market in years 1 and 2. So you want to kind of have a good launch. The other model, so setting aside that lottery discussion, exclusive contracts and franchise agreements. The state sits in its position of control. It's going to issue a limited number of privileges to platform providers, operators, what have you. And it's going to be based on competitive bidding, the same as a lot of other products and projects that the state buys, enters into. It would go through a competitive bidding process. I walked you through New Hampshire and New York this morning. Those are examples. The way that this would work out, statute would likely set some of the parameters and priorities for the process. So the examples that I highlighted, New Hampshire kind of front-loaded qualifications, background, experience, things like that. And then after they went through an initial phase, selected based on the expected revenue share and financial benefit to the state. New York did something not dissimilar, where the initial review was based on the proposal for the health and growth of the market, financial security, financial background, and then there were particular weight put on a proposed tax rate. So you have kind of that two-step process. All of that set in statute, and of course the administrative agency is then responsible for actually conducting the competitive bidding process, getting essentially the RFP, request for proposal, ready and putting it out so that they can get the market applicants, reviewing the applications, and selecting the agents who will contract with the state to offer sports wagering. A huge consideration that I've highlighted here is, are there going to be a minimum number of operators? Is there going to be a maximum number of operators? Graham highlighted potentially some of the consequences there with getting those high quality operators in place if revenue is one of the key considerations. The risk and weakness to going through this model, and that's without saying that there has been any demonstrated, weakness or failures in the states that have done this, is that all of this needs to be leveraged through the administrative agency. So the challenge is positioning the administrative agency to be able to conduct this process and negotiate towards, the type of beneficial market outcome that Representative Odie was talking about earlier. So I said a lot, my apologies, but the two big decisions are you going to have a lottery system where the state is kind of offering its own games through its lottery, or are you going to establish that bidding process where the state solicits interest from third parties to operate sports wagering in the state, and selects based on the boundaries of that bidding process.
Thank you, Tucker. Does anyone that's on the screen digitally joining us remotely, do you have any questions for Tucker based on what he's described in terms of the state model, lottery, or the contracted model?
Tucker, is there an appreciable difference in access or use, whether it's a state series of products or whether it's operators that have their own products?
I can't give you a definitive answer based on any particular research, but I think the narrative that you've heard over the last 2 weeks is that it's easier when it's an app that you don't have to have just to participate in sports wagering in that specific state. So I guess the more regional or national you can make the approach here, the better. And if you look at some of the analysis in the early sections of the report, that is considered a barrier to market. If you have to, go and access Oregon's, I think it was called Scoreboard app or website, and develop an account with the state while you're there, that becomes a barrier to customer access to the product. And right now you're existing in a model, right, where there's no federal standards for this and every state is ring fenced. You've heard the term geofencing, right? So what you're doing in your approach to the state control model is you're saying the state is going to take down the fence and allow access to some sort of product here. There's benefits to having a product that isn't necessarily specific to Vermont. And again, as you put earlier, all of these decisions are going to depend on what is the institutional policy, purpose, principle, whatever that's being applied here.
So in the first meeting we had, just to remind the committee, we outlined some of those state interests. What are the state interests? We want to maximize revenue, so that was important. We want to give the administrative agency, I forgot the term you used, but
regulatory levers.
yes, consumer protection, so things like that. So that's the lens that we're kind of looking at these decision points, right? What I heard from this conversation just now is obviously we're the island and everyone around us now is participating in sports betting. And that might be the reason why we wouldn't, among other reasons, have a Vermont specific sports betting book, because then our folks that travel here and our neighbors it would be harder to access that.
And then the launch is the other part of it.
Right, of course.
I brought that up briefly. I don't know if he did this intentionally or not. I would assume he did because Graham is excellent. But when he pointed out some of the states that have had trouble setting competitive lines, he actually named lottery states.
Right. And I remember that from testimony. New Hampshire, DC, not only was it complicated, but I remember that it was a financial disaster in terms of them being able to derive any revenue from that.
They had a difficult first year. And if you look at the revenue reports, they've rebounded, but that first year, 18 months, was very difficult. And I think they actually lost money.
Yes. Okay, so any other thoughts or questions or for Graham or Tucker on the secondary kind of decision, which is, are we leaning more towards setting up a state lottery for sports betting, or are we leaning more towards the exclusive contract competitive bid process? Based on our stated goals of revenue, we need competition, we want consumer protections.
I'll just chime in here and say it seems pretty clear to me that the contracting and bidding system is the most beneficial, the least amount of risk, and again, avoids us having to have expertise, infrastructure, and resources that we'd have to set up in addition to running that system.
I agree with this. Yeah, Representative Carolodi, I agree with that.
Matt?
I agree with that
I'm
too.
sorry, John. John, you agree with that as well, the contracting approach?
Yep, same reasoning as Chris.
Matt, are you with us? Are you able to communicate your preference for state setting it up or exclusive contracts?
Yes, Madam Chair, I am here. So, yes, no, still, from what I understand, my intent with this is to still go in the state direction.
Okay, you're thinking that the Vermont Lottery would set up a sports betting book? Or are you thinking that the state lottery would do a competitive bid process and select operators with an exclusive arrangement, exclusive contracts?
I think the exclusive contracts is the way to go with that, with the state monitoring those contracts.
Right.
And vetting them.
Right.
Correct.
State oversight. Okay.
Yes. So yes, to house it within the lottery structure makes sense, and then to have them source, vet, and oversee said contracts.
Okay.
I would also point out that while we don't have an opinion on that aspect either, I would point out that if ultimate bidders or licensees who are successful under that kind of a model, without having the state come up with its own sort of app or sports book, if they already offer fantasy sports games in Vermont under Vermont law, they already have a regulatory regime in place to comply with Vermont's consumer protection laws on that front. So they may find it faster and easier to adopt for all sports betting, those metrics that have already been imposed on fantasy sports gaming. So.
That's a good point. And that's something we're going to bring up again when we talk about the consumer protections is, are we going to use, as we started to talk about last meeting, the fantasy sports kind of regulatory structure, or at least the qualifications and the regulations is kind of a base for sports betting. As the current commissioner of the Vermont Department of Liquor and Lottery, I also think that it would be, for one, speed to market. I think in terms of approach would be the exclusive contract where you do a competitive bidding process and not have one sports book. One, seems to be a lot of risk that Tucker identified. And that Graham had been talked about is the ideas that you want some competition, particularly with the same lines as Vegas, and not confident that the sportsbook app for Vermont would achieve the stated interests that we would like. So I think the committee is recommending that we go down the approach of the exclusive contracts. Within that, we will need to, I think, talk more about, and I don't know that this is for today, because I think that part of what we want to talk about is getting into what Graham was talking about, which is what are those other and Tucker, you mentioned this too. Are there going to be a minimum number of operators? Are there going to be a maximum number of operators? And I think that Graham was really succinct in pointing out that the matrix there, right? Many operators, low tax rate equals this estimate, fewer operators, higher tax rate, this. So I think that might be part of the conversation when we get into the tax and revenue meeting. Does that make sense to everybody instead of trying to use the next 40 minutes to dig into that, or we could do that. It's up to you. I feel like we're making some good progress today in terms of a regulatory framework. I feel like getting into the limits and caps and number of franchises is going to require a lot more of an expanded conversation around tax and revenue.
I agree. I think the number is going to go to how much revenue is generated. So I would favor postponing that conversation until we can cover that entire
Tax and
landscape.
revenue.
Yeah, just hold off.
Does that sound good to everyone on that? We've made some good progress today to have that conversation digging deeper into the structure of the exclusive contracts in terms of number of operators, minimums or maximums when we have that tax and revenue discussion?
Yes.
I agree.
Okay. So do we have anything else we want to discuss while we're here today? Otherwise, we've given ourselves 40 minutes back, which would be nice, right?
I'm always in favor of efficient meetings, Madam Chair.
Excellent. I really appreciate everyone's time. I think we're all set today and we'll adjourn the meeting if there's nothing